Mr. Malcolm Archibald, QC, is our next speaker. Mr. Archibald was called to the Bar of Ontario in 1955. He has been associated since his call to the bar with the firm of Messrs. Weir and Folds in Toronto, in which he is a partner. He is a member of the Estate Planning Council of Toronto, a past chairman of the Wills and Trusts section of the Ontario branch of the Canadian Bar Association, and chairman of the advisory committee to the Ontario Law Reform Commission on Estate Administration. Ladies and gentlemen, Mr. Malcolm Archibald.
Thank you, Marvin. I said to Marvin, if his price was high enough, perhaps I'd undercut it by letting you write to me direct. When David Fuller spoke to me about doing the paper, and my topic was to be estate administration after the repeal of the Succession Duty Act, he said, well, probably your paper will be 7 blank pages. Well, I have managed to find some things to talk about. Maybe you'll be sorry I did. I am not going to try and talk about all the things you need to know about estate administration. Rather, what I'm going to do today is to talk about things that I feel are of interest in the result of not just the repeal of the Succession Duty Act, but the various other legislative changes, such as the passing of the Succession Law Reform Act, the Family Law Reform Act, and also going to say something about the Quebec Succession Duty Act. I'd like to begin by saying something about lawyers' fees since the repeal of succession duty. When I first mentioned that I might do this, it was suggested to me perhaps that it was unseemly to discuss fees at such a highfalutin meeting as the March Special Lectures. However, I don't think that's the case, and in fact, we certainly did receive one written request asking that somebody talk about fees. And I think that everybody does have. Well, you may not like what I have to say. I'm just going to say it. I heard a story the other day about the lawyer who sent an account which read something like this: to attending to execute a codicil, but you were dead. And I said to myself, well, that's all very well, but what was the charge? With the repeal of succession duty, I think we really do have serious concerns about the applicability of the solicitor's tariff. If you remember, the solicitor's tariff reads like this: for the preparation of the application for probate or administration, succession duty schedules, and estate tax returns, and all services and attendances in connection therewith, and for all services incidental to the administration of the estate, exclusive of sales and motions in court, up to but not including the first passing of accounts. Now, that's what the tariff says. Now, you may remember that this tariff came into force in about 1968. Prior to that, the tariff had 3 separate sections, namely application for probate, which had a fee, preparation of the Ontario succession duty return, and preparation of the estate tax return, which then would have been the Dominion Succession Duty Act. Now, this tariff was very unsatisfactory because it really only covered about half the ordinary legal fee. It was customary to add to your bill an extra amount for settling succession duties and so on, that meant that in most cases the lawyer's bill came to about double the tariff items. Now, when estate tax was repealed and capital gains tax introduced in its place at the end of 1971, there was some concern expressed then as to what effect that would have on the tariff. However, due to the greatly increased complexities of terminal income tax returns, which were often prepared by the estate solicitor, it was felt, I think, in general that there had been no reduction in the work being done by the solicitor, and the tariff was not amended and continued to be used. However, with the repeal of the Ontario Succession Duty Act, I suggest that the work of the solicitor in estate administration has been considerably reduced. In the existing tariff, the aggregate value on which the percentages are based is stated to be, quote, deemed to include all items required to be included for returns filed under the Succession Duty Act of Ontario at the value determined under the Act. Therefore, technically, there may be, in fact, no proper basis for arriving at an aggregate value on which to apply the percentage. While it might be possible to suggest that you could arrive at an aggregate value by determining what would have been included if a succession duty return had been filed, morally it seems to me that it is improper to try and apply the existing tariff for services to an estate when so large a part of what the tariff was expressed to cover has been removed from the services. Accordingly, I suggest to you that until the Rules Committee provides us with a new tariff for services in the administration of estates where the deceased died after April 11, 1979, that solicitors should be charging on a quantum merit basis. Now, obviously, this makes life more difficult because it requires the keeping of proper time records. It makes it almost impossible to estimate in advance the charges that will be made for your services. It makes the drawing and settling of the final account more difficult. It makes it more of a problem of splitting your account between solicitor's work and executor's work. It makes it more difficult for the surrogate judge or the taxing officer to determine whether the fee was appropriate. Now, it seems to me that the major problem for solicitors doing estate administration work is that the largest part of the work now being done really amounts to the doing of personal representatives' work, rather than the provision of legal services as such. The preparation of the application for probate, the preparation of succession duty returns, the ad for creditors, transmission declarations, notarial copies of probate, releases for beneficiaries to sign, these are services that have been considered to be legal services. The most time-consuming services, however, such as the preparation of the inventory of assets, the actually handling of the transfer of assets, banking arrangements, preparation of income tax returns, and preparation of estate accounts for approval or passing, all of these have usually been considered properly the work of the personal representative. I must say that I fail to understand if the preparation of a succession duty return is solicitor's work, why then the preparation of a terminal income tax return should not also be considered solicitor's work. Now, the problem facing the Rules Committee in trying to determine if a new tariff could be arrived at is the question of the need to incorporate into such a tariff personal representatives' work. I think it's interesting to note that in Manitoba, there is a tariff with percentages roughly the same as in Ontario. But if the personal representative is a corporate trustee or a solicitor, then the solicitor is only to receive 40% of the tariff for legal fees. In Saskatchewan, again, the percentages are similar to Ontario. But again, here if the solicitor does the bulk of the executor's work, and if the personal representative does his own work, the solicitor only gets 60% of the tariff. If the services that you are going to provide for the executors largely consist of doing executors' work, then I recommend to you that you obtain written instructions from the executors confirming the arrangement. I base this recommendation on the case of solicitors in the 1973 Ontario reports. In that case, the taxing officer McBride refused to allow a fee to estate solicitors for doing alleged executors' work. And he said, "I know that it is common practice for solicitors to perform what they are pleased to call executors' work and then charge for it on the basis that it is legal work. I do not think they have any right to do that, at least not unless they have clearly explained the issue to the executor client and have received his instructions to do that work for him. If they get that far, they had better get those instructions in writing." There is, of course, not the slightest evidence in the present case that this issue was ever present in the minds of the solicitors or the client. It just did not occur to them. However, I am sure that if the executor had been told that the delivery of the transmissions were going to cost her an additional fee, she would have made arrangements to do so herself, or at any rate, she would have had that option open to her. Now, I have drafted in my material a possible letter. We used to always rely on Ron Burroughs' letter, and I tried to find my copy, but I couldn't find it, so I had to draft my own. It is just a sample of what you might consider writing. You will also find a sample in the CCH on estate planning in a letter with more detail, and you'll have to decide yourself exactly what you want your own letter to say. But there is in my paper a letter that you might wish to consider using. If our fees hereafter are to be based on quantum merit, I'd refer you to a statement in McDonald, Shear, and Hull on probate practice, where the authors set out the principles governing fees in estates in excess of the tariff amount as follows. The determining of the appropriate fee in these latter cases should be arrived at by applying the considerations normally applied in taxing a solicitor's account, being the amount and character of the services rendered, the labor, time, and trouble involved, the character and importance of the services rendered, the amount of money or value of the estate, the professional skill and experience called for, the character and standing in the profession of the solicitors involved, the results obtained, and the ability of the clients to pay. Now, if the solicitors are really doing the bulk of the executor's work, is it not reasonable that they charge the executors a percentage of the usual executor's compensation? There was a report of a subcommittee on fees of the Wills and Trusts subsection of the Canadian Bar Association in 1971, of which I was a member. In that report, it was suggested that where the solicitor was doing a substantial part of the executor's work, that a charge of 1/3 of the usual executor's compensation would be reasonable. It seems to me now that the appropriate percentage might be higher. Of course, you must remember that the usual fees allowed executors include an allowance for responsibilities which rest on the shoulders of executors and which they cannot delegate. The difficulties in setting an appropriate fraction for the solicitor lies in knowing what fraction of the total allowance to an executor relates to the responsibility aspect. If you are considering an agreement with the executors to provide executor's services for a fraction of the usual executor's compensation, then you should give consideration to a decision of the Honourable Mr. Justice Osler in Re de Rosier and Conrad in the 1975 Ontario reports. In that case, executors signed a direction to the solicitor to undertake certain named services, quote, which are ordinarily performed by the executors in the final distribution of the estate. I agreed to pay him the usual executor's compensation fee awarded by law for such services, quote. The solicitors then purported to charge the executors an amount equal to the usual 5% of the aggregate value of the estate. Mr. Justice Osler found the agreement should be cancelled pursuant to Section 26 of the Solicitors Act because the terms were not fair and reasonable, and he directed the bill to be taxed in the ordinary manner. He stated, quote, no layman executing the agreement as requested would have much idea of the size of the obligation he was incurring. He would certainly not anticipate charges for work done before the date of the agreement, and the, quote, usual executor's compensation fee awarded by law is not something readily ascertainable by the client, or indeed by anyone else, as no such thing exists, quote. I would respectfully suggest that the judge's statement does not actually represent the facts of life in the surrogate courts today. Nevertheless, possibly the problem of unfairness could be overcome by setting out in the agreement with the client the usual basis on which executors' fees are allowed and making clear that the fraction claimed by the executor would be based on the usual percentage and would be reduced if in fact the executor was allowed less than the usual percentage on the passing of accounts. Now, in this whole area of the setting of solicitors' fees, I am very much aware of the problem that this is going to cause the profession. In the past, historically, we have depended on operating a reasonable estate practice on the fact that our fees for services in estate administrations, particularly in the larger estates, were generous, and they compensated us for the fact that we lost money on little estates, we lost money on will drafting, all that sort of thing. Now, if we lose that so-called gravy, what is going to happen to us? It really is a problem. It is a problem because I think clearly it means that we are going to have to start making proper charges for will drafting and regular services, because we will no longer be able to afford to carry on those kind of things at a loss if we don't have the other end to make up the difference. I happen to be a member of the subcommittee of the Rules Committee on Surrogate Court Rules. I would be most pleased if any of you have any views or submissions that you would like to make, to write to me or to write to Chief Judge Coulter, who is the chairman of the subcommittee, expressing your views. I feel relatively confident that the subcommittee of the Rules Committee is not going to rush through any recommendations to the Rules Committee without giving the profession a chance to be heard, but we do need to hear your ideas. Obviously, it is a very serious problem that the profession must cope with. I'd like to turn to something very simple and very practical now, and that's just simply to say something about the inventory of assets and safety deposit box listing. Obviously, you don't need a succession duty release to get into the safety deposit box anymore. But the personal representative, the bank is not going to let the personal representative in until he has his grant of probate. So you're going to have to get your inventory to do your surrogate court paper, you're going to have to get a listing of the contents of the box. I suggest to you that when you go to the bank, that you have, the bank employee will insist on being present, but I suggest that you obtain a listing, whether he does it or you do it, a listing, and that you both sign it. I think the personal representative should have the protection of that signed list, in particular if there are some bearer assets in there, so that nobody, or if there aren't any there, so that no one can come along afterwards and say, well, what happened to thus and so? Where is it? And at least you'll have some evidence that it wasn't in the box or it isn't in your pocket. I don't think you need to concern yourself when you're making the listing about taking down certificate numbers and that sort of thing, because you certainly don't need that for your initial inventory, and I suggest to you it's more practical to get those numbers and so on when you are actually have the certificates in your hand. There's less chance for error, and that is probably a more reasonable way to make your list. Now I'd like to turn to consideration of some of the changes under the Family Law Reform Act. Generally speaking, the Family Law Reform Act only deals with rights to support during lifetime and to the division of assets on a marriage breakdown. However, there may be some situations where the Act will have an effect on estate administration. For example, the court may order an obligation and liability for support of a dependent to continue after the death of the respondent and to be a debt of his or her estate. If a support order does not expressly state that it's to go on after death, then it automatically terminates. If an order has been made that continues after death, it is open to be changed if there's a material change in circumstances, and often death might be a material change in circumstances. If an application for a division of the family assets was commenced before the death of one of the spouses, this application can continue after the death. It is interesting to note that if no such application has been commenced, a surviving spouse has no right to a division of family assets after death under the Family Law Reform Act or the Succession Law Reform Act, and can only obtain provision for support under the dependents' relief provisions of the Succession Law Reform Act. It does seem somewhat illogical that the spouse's rights under the Family Law Reform Act on the breakdown of a marriage may be greater than their rights on the death of a spouse. I believe there has been some movement to have the Succession Law Reform Act amended. My concern about an amendment to bring the two acts into conformity is that it would lead to considerable litigation in the administration of estates, as appears to have been the case under the Family Law Reform Act. You should also remember that a surviving spouse may have been given a right of exclusive possession of a matrimonial home for life or some lesser period pursuant to an order under Section 45 of the Family Law Reform Act. However, that can be varied based on a change in circumstances. I'd like to say something about presumptions of advancement. Until 1975, there was a rule of law applying a presumption of advancement in the question of the ownership of property as between husband and wife. That is to say that if the husband conveyed property to his wife, it was presumed that the wife was to take her interest beneficially. However, the reverse was not true. If a wife transferred property to her husband without consideration, there was no presumption that an advancement was intended, and it was presumed, applying the principle of resulting trusts, that the husband held in trust for the transferor. Obviously, there was a need for equality so that the rule would be the same for transfers in either direction. However, instead of changing the law to provide for a presumption of advancement in transfers from a wife to a husband, they went the other way. Section 11 of the Family Law Reform Act provides as follows. the rules of law applying a presumption of advancement in questions of the ownership of property as between husband and wife is abolished, and in place thereof the rule of law applying a presumption of a resulting trust shall be applied in the same manner as if they were not married, except that, A, the fact that property is placed or taken in the name of spouses as joint tenants is prima facie proof that each spouse is intended to have, on a severance of the joint tenancy, a 1/2 beneficial interest in the property, and B, money on deposit in a chartered bank, savings office, credit union, or trust company in the name of both spouses shall be deemed to be in the name of the spouses as joint tenants for the purposes of Clause A. This means that there's now an onus on the surviving spouse to show that the deceased spouse intended a true gift of the property transferred by the deceased to the surviving spouse without consideration, and that the surviving spouse therefore owns the property beneficially and not in resulting trust for the estate. This could be a particular problem in situations where the beneficiaries may not be on good terms, such as where there has been a gift to a second wife and the beneficiaries of the estate are children of a first marriage. If gifts are being made between spouses, it seems to me desirable that there be a document signed by the donor confirming that the donee spouse was intended to have the beneficial interest in the property. And as the section is retroactive, I would recommend to you that you get confirmatory declarations concerning past gifts as well as future gifts. You should remember that Section 8 of the Family Law Reform Act provides a claim for contribution to property. And that section reads, where one spouse or former spouse has contributed work, money, or money's worth in respect of the acquisition, management, maintenance, operation, or improvement of property other than family assets in which the other has or had an interest, upon application, the court may by order direct the payment of an amount in compensation therefor, or award a share of the interest of the other spouse or former spouse in the property appropriate to the contribution. And the court shall determine and assess the contribution without regard to the relationship of husband and wife or the fact that the acts constituting the contribution are those of a reasonable spouse of that sex in the circumstances. It seems to me that a right to claim under this section is not terminated by the death of the spouse. Mr. Justice Grange in Fisher versus Fisher, a fairly recent decision, covers, not in a death situation, but covers the history and intent of that section. You should remember that under the Family Law Reform Act, domestic contracts can now deal with rights upon death, and therefore a properly executed contract can contain contractual obligations which must be met by the personal representatives of the deceased. I'd like to speak to you next about some problems in estate conveyancing. The Family Law Reform Act abolished the common law right of a widow to dower. Therefore, we no longer need to concern ourselves about a release of dower in a deed from an estate where the deceased died after March 31st, 1978. And I've already mentioned there are no rights to a division of family assets after death, so we don't have to worry about that. Section 40 of the Family Law Reform Act, dealing with rights of possession in a matrimonial home, states, a right of a spouse to possession ceases upon the spouse ceasing to be a spouse. In my opinion, that section means that any right of possession of the non-owning spouse terminates on the death of the owner spouse. Accordingly, there is no need for any kind of spousal consent by the widow or widower when the personal representative of a deceased owner spouse is conveying property. Now, something I find very surprising, one would have expected that there would be a provision in the Registry Act, similar to the old provision, exempting the need of an affidavit of age or marital status with respect to a person executing an instrument in his capacity as executor or administrator or trustee under a will. In fact, subsection 10 of Section 42 of the Registry Act, as amended, provides as follows. Subsections 5 and 6, these are the sections relating to affidavits of spousal status, do not apply to a person executing an instrument in his capacity as a public trustee, official guardian, trustee in bankruptcy, executor or administrator who is not selling for the purpose of paying debts of the estate, trustee of a religious institution, or trustee of a school board, and any other person who may be designated by regulation. And I personally am at a complete loss to understand why an executor or administrator who is selling for the purpose of paying debts should be required to complete a spousal affidavit. I hope that there will be an amendment to the Act to remove this anomaly. If you have beneficiaries concurring in a deed pursuant to Section 22 of the Devolution of Estates Act on a sale made for the purpose of distribution, it would seem to me that you would require an affidavit of spousal status from each beneficiary. This is because subsections 5 and 6, requiring affidavits of spousal status, refer to a deed, quote, that is made by a person, quote, and I do not think you could be sure that the beneficiary concurring was not making the deed. In addition to considering whether an affidavit of spousal status is necessary, we should also think about whether the spouse in such case has any interest under the Family Law Reform Act. If you look at Section 39 of the Family Law Reform Act, it provides, quote, property in which a person has an interest and that is or has been occupied by the person and his or her spouse as their family residence is their matrimonial home. The word interest is not defined, and I would be afraid that a beneficiary who is joining to concur in a sale, even though he did not have a vested interest in the property, might well have had an interest within the meaning of that section. In that case, if the beneficiary had by chance occupied with the property with a spouse, then of course the spouse's consent to the deed would be necessary. Now I'd like to turn to some considerations of effects of the Succession Law Reform Act. And the first thing I'd like to say something about is the search for beneficiaries. Because under the new acts, children born outside of marriage are entitled to share on an intestacy or through a class gift under a will, we now have to consider what is required of the personal representative in searching for persons born outside marriage. Section 28 of the Devolution of Estates Act, as amended, reads as follows. A personal representative shall make reasonable inquiries for persons who may be entitled by virtue of a relationship traced through a birth outside marriage. 2, a personal representative is not liable for failing to distribute property to a person who is entitled by virtue of a relationship traced through a birth outside marriage where A, he makes the inquiries referred to in subsection 1, and the entitlement of the person entitled was not known to the personal representative at the time of distribution, and B, he makes such search of the records of the Registrar General relating to parentage as is available for the existence of persons who are entitled by virtue of a relationship traced through a birth outside marriage, and the search fails to disclose the existence of such a person. The first part of the section imposes an obligation on the personal representative to make reasonable inquiries, so we must consider what constitutes reasonable inquiries. I think it's useful to remember what we did in the past in searching for beneficiaries. We made inquiries of the members of the family who we expected to know who were in the family, and that usually was all that was necessary. And I believe that the personal representative should begin in the same way as before, by making inquiries within the family, but specifically asking whether there is any knowledge of children born out of wedlock. If the family know of no children born out of wedlock and have no reason to believe that there are any, then it is my view that you have made all the reasonable inquiries that are necessary. In the past, we might have had a problem looking for a missing heir. For example, a child might have gone to another city or country some years before and not have been heard from since, and it would not have been known by the family whether the child was alive or dead, or whether the child was married and had any children. In such cases, the executor or administrator might have advertised in the city where the child was last heard of, or he might have hired a private investigator to make some inquiries. Similarly now, if you have some reason to believe that there might be a specific child born out of wedlock, it seems to me that you would want to consider some kind of advertising or private investigation. In the past, if these sort of inquiries failed to find the missing heirs, the practice was to make an application under Rule 607 to a judge of the Supreme Court. Then the judge would direct a reference to the master to inquire into and report who are the heirs at law, and as such entitled to share in the estate, and to report his findings to the court. And I would suggest that that same procedure could be used for children born out of wedlock. Now you will remember that subsection 2 requires a personal representative, if he wants protection, to make certain mandatory searches in the Office of the Registrar General in Ontario. Now, there are three kinds of registrations you'll be looking for. Firstly, under the provisions of the Children's Law Reform Act, a person may file in the Office of the Registrar General a statutory declaration affirming that he is the father of the child. So you can find that kind of registration. Secondly, the Children's Law Reform Act provides that the registrar clerk of every court in Ontario shall furnish the Registrar General with a statement in the form prescribed by the regulations respecting each order or judgment of the court that confirms or makes a finding of parentage. Now, these orders are filed both under the name of the child and under the name of the parent. And then since March 31st, 1978, there's been cross-indexing of the father's names where a declaration by the natural father is filed at the time of birth or subsequently pursuant to the provisions of the Vital Statistics Act. Now, I understand that the Registrar General is not cross-indexing under the name of a mother, where there is a declaration filed under the Vital Statistics Act or where there is a court order of maternity. So this cuts your searching in half. You do not need to search female names at the Registrar General's. Furthermore, you're not going to find much on your searches for a few years because only declarations or orders filed after March 31st, 1978 will be indexed under the name of the father. What you're going to be searching on an intestacy, if you have a deceased male, you're going to search the name of the deceased male. If you have then down to the children line, you know the name of a deceased male child, and there may be representation there, you're going to want to search the name of the deceased male child, and so on down the line. But it's the male deceased father's name you're searching. You should remember, of course, also that if you have a class gift under a will, then you will be searching the name of the father of the class, and if it is a per stirpes gift, you will be also searching the name of a deceased male child. Now, something that I came across when I was preparing my paper that I think is of concern and interest is that consideration should be given to the position of a bona fide purchaser for value from an estate with respect to the claim of a beneficiary who surfaces after a conveyance has been made. Take, for example, the situation where land is vested in the next of kin because 3 years have passed since the date of death, and the next of kin purport to join in the deed. However, in fact, there is a claimant, whether born out of wedlock or not, who is entitled but was overlooked. In this case, I am afraid that the claimant may have a legal claim against the land against which the defense of purchaser in good faith and for value will not avail. The same problem could arise where there was a conveyance pursuant to the Devolution of Estates Act for purposes of distribution with a majority of the beneficiaries concurring. Then when the missing beneficiary shows up, you find that you no longer had the concurrence of the majority. So I would then be afraid that the people who had not joined in the deed would not be bound. In my opinion, the wording of subsection 3 of section 28 may have indicated that the draftsman thought that an innocent purchaser for value would not have any problem. But I don't think the section itself is nearly strong enough to give the purchaser any protection from the claim of the missing beneficiary. Jim Wardlaw, in his paper in the Society's continuing education program, Real Property, What Now?, suggests that the purchaser should requisition proof that the personal representative has made reasonable inquiries and made searches in the Registrar General's office and suggests a recital to that effect in the deed, which would, of course, be verified by an affidavit. However, Mr. Wardlaw agrees with me that while this suggestion would be helpful in drawing the personal representative's attention to the necessity of searches, which might cause a missing claimant to surface, nevertheless, the purchaser is still at the mercy of an undisclosed legal claimant. I would hope that there could be a legislative amendment to give positive protection to a bona fide purchaser for value without notice. I'd like to speak briefly about the dependents relief provisions of the Succession Law Reform Act. I think you should note that the provisions can now apply on an intestacy as well as under a will. The considerations into which the court is to inquire have been made more explicit and broader. The court is no longer limited in setting the allowance to the amount a dependent would have been entitled on an intestacy. Section 79 of the Act permits certain inter vivos transactions to be deemed to be part of the net estate for the purpose of ascertaining the value of the estate and being available to be charged for payment by a support order. Probably the most important change of which you should be aware is the broadening of the class of dependents. Under the old Dependents Relief Act, the only dependents were the wife or husband of a testator, the child of a testator under the age of 16 years, or the child of a testator over that age who through illness or infirmity was unable to earn a livelihood. Now the class of dependents has been broadened to include common law spouses, parents, grandparents, brothers and sisters, children of any age and whether born in or out of wedlock, and also includes a person whom the deceased demonstrated a settled intention to treat as a child of his family, which presumably could include stepchildren. There is an important rider, however, and that is that to qualify as a dependent, the deceased must have been providing support or have been under a legal obligation to provide support for the dependent immediately before his death. As I read Part 2 of the Family Law Reform Act, a spouse has a legal obligation to support the other spouse in accordance with need, to support a child who is unmarried and under the age of 18 years in accordance with need, and in certain circumstances a legal obligation to support parents and grandparents. Therefore, in my opinion, a spouse, child, or parent who could have obtained on the facts a support order immediately before death under the Family Law Reform Act would qualify as a dependent even though there was no court order for support and no actual support by the deceased. There appears to be no legal obligation on a parent to support a child over the age of 18 years, even if the child is handicapped or infirm. However, if a parent gives financial support to one of these dependents, clearly that opens the door to the child or to the public trustee on the child's behalf, where the child is a patient in the appropriate psychiatric facility, to make a claim under the dependents' relief provisions. This raises the question, will people be reluctant to give financial support to dependents for fear of substantial claims against their estate by the dependents or on the dependents' behalf after their death? I'd like to mention to you a decision of Her Honor Judge Sidney Diamond, dated December 10, 1979, in the case of the estate of Marie Marguerite Davies, which is as yet unreported. In her decision, Judge Diamond refers to the use of the word support in the new provisions, both as a basis for establishing dependency and also in the section which provides for the order. She notes the change from the word maintenance in the old Dependents Relief Act. She looks at a number of dictionary definitions of the word support and concludes that support, as used in the Succession Law Reform Act, includes not only furnishing food and sustenance and supplying the necessaries of life, but also the second meaning of giving physical or moral support. She says, for example, if a living husband had been accustomed to reading aloud to his wife, whose sight had failed, it may well be that for her support, sufficient money should be provided to pay for a reader to substitute for that husband. Judge Diamond found in the facts of the case that the applicant widower was a dependent of his deceased spouse and gave him on certain terms the right to occupy the house owned by his late wife. If Judge Diamond is correct in her interpretation of the meaning of support, the legislation goes a lot farther than I would have personally anticipated. Now I'd like to speak about the Quebec Succession Duty Act. Quebec is now the only province in Canada levying succession duty. The Succession Duty Act 1978 affects the estates of persons dying on or after April the 19th, 1978. Subsection 2 provides that all property situate in Quebec transmitted owing to death is liable for duties. However, there is a very important exception to this found in Section 24, which provides as follows. No duty is exigible on movable property and apothecary claims transmitted to a person who at the time of death is resident and domiciled outside Quebec by a person who is at the same time resident and domiciled outside Quebec. So if you have the deceased and the beneficiaries all both resident and domiciled outside of Quebec, you do not have, in the case of movables, any problem with Quebec duty. Now this is very important because it means that, for instance, if you meet that test and you have shares, say, in Canadian Pacific, which is a company with its head office in Montreal. In the old days, you might have needed a Quebec succession duty release, You might also, in fact, if the stock had been ex-dividend, had to pay Quebec duty. Now, that should not happen. But your transmission declaration, in my view, should recite that the deceased and all the beneficiaries are both resident and domiciled out of Quebec. And the present stationer's forms do not say that. So if you are, I'm hoping that they will amend their forms, but until they do, if you have a Quebec stock to deal with, I would suggest that you amend the present form to make clear that the beneficiaries and the deceased are all resident and domiciled outside of Quebec, and then you should have no problem transmitting those shares in Toronto. Now, a major change in the Quebec Succession Duty Act is that Section 3 purports to tax every beneficiary, resident or domiciled in Quebec, to whom property situated outside Quebec is transmitted owing to death, regardless of the domicile or residence of the deceased. Thus, this is an accession tax, and a case on the BC accession tax is going to the Supreme Court of Canada. So we don't know yet for sure whether the BC legislation was ultra-virus. The lower court said it was. But the Quebec Act is different again, so we may not know for some time whether the Quebec Act is intra-virus. What do you do if you're in the position of having a Quebec residence in resident, or a beneficiary resident in Quebec? It seems to me that if you have a succession duty clause in your will exonerating the beneficiaries from the payment of succession duty, you could not avoid paying the beneficiary's duty without his consent. Because if you wound up the estate and didn't pay the duty with the hopes it would go away, that beneficiary might be very annoyed at not having his duty paid. At lunch, we were having a discussion at the lunch table, and one of the gentlemen from BC said, I was too worried about Quebec, that I was just too close to it. If I was out in BC, I wouldn't worry about these things. If you have an estate that isn't immediately distributable, I know we have one situation in our office where we simply are not filing or paying. We're waiting to see what will happen. But you are going to have a real problem, and I don't know what your real answer is if you have an estate that you want to wind up. I haven't time to talk about the in fact, I haven't time to talk about anything. I was going to enlighten the gentleman from BC about the BC Probate Fees Act, but he'll have to wait and read my paper.